A very warm welcome to Law and Life. Today we will be having the first conversation on Indianization of our legal system with the senior advocate of Supreme Court of India, with Subodh Markandeya. So sir, I can raise my first question on this issue.
Hello, good morning.
Good morning, sir. Good morning. So can I raise my first question?
Yes,
Sir, on 19 September 2021, the Chief Justice of India, N.V. Ramanna, while paying homage to late Supreme Court Justice Mohan M. Santanagodar, who had died of COVID-19, pleaded for what he called Indianization of our legal system. It raised a raging debate is now going on. What are your views on that?
so the Indianization of British era laws ought to have started soon after our independence. In 1947 itself, important British made laws, including the Penal and Criminal Procedure Codes and the Indian Evidence Act, were antiquated by almost a century. Apart from antiquity, those laws are not aligned with our native sensibilities, and they are also unsuited for modern needs of our young nation. You see, in 1986, Justice Rama Joy, then a judge of the Karnataka High Court, had delivered three very illuminating lectures at the law faculty of the Cochin University of Science and Technology. Those lectures dwelt on the theme that ancient Indian treatises and law furnished a rich source material parallel to the modern concepts of law. A book containing these lectures was published by Lucknow's Eastern Book Company. I know it because the National Archives of India sent me that book for review in the press. But in those days, concerned authorities at the top were very averse to such ideas. Anything from ancient India was an anathema to them.
So this raised to me this next question. What exactly will the process of Indianization involve?
The process of Indianization would involve, on the part of Parliament and the state legislatures, enactment of laws based on and inspired on the indigenous source material available in the ancient Indian treatises, including a law corresponding to the General Clauses Act of 1897. On the part of the courts, it will involve diminishing reliance on Benyon, Grays, Crawford, and Maxwell, and more reliance on the indigenous treatises on interpretation like Mimamsa.
Don't you think the whole process is very challenging?
Yes, I recognize that whole process of Indianization is not free from challenges and difficulties. We'll need to adapt those ancient concepts to our modern conditions and needs. Also, we'll have to weed out a lot of the sense unsuited to modern times, and that's also a challenge. But bodies like the Law Commission can help overcome all these challenges. Dedicated scholars well versed in ancient Indian source material will be needed. Effective interface between the Law Commission and the experts on ancient Indian source material will also have to be created.
So in one of your recent video interviews, which I saw, you have said that you have cited Kautilya Arthashastra in the Tihar Jail Inquiry case, where you were Supreme Court appointed amicus curiae. Kindly share your experience on that.
Yes, Justice J.C. Jain, who was then the only district judge in Delhi, was holding the Tihar Jail Inquiry. He was a bold and erudite and also very upright judge. So one day what happened that after the day's hearing was over, He told us much before the conclusion of the evidence that tentatively he had formed an opinion that petitioner had almost proved his case. But so what? What's the sequitur? He asked. What do we do next? This was a very difficult question. Our service laws and penal laws had no specific provision for punishing jail officials when they denied the prisoners' rights to water, to food, to sleep, and other rights under the jail manual, and also under the Indian Prisons Act and other laws. In those days, I had brought a Kautilya's Arthashastra by Professor R.P. Kamble of Bombay University. He was a very celebrated scholar, and I was reading it in my spare time. Professor Kamble's work is in 3 volumes. The first volume contains highly annotated Sanskrit text. Second is the English translation. And third is his own commentaries. So I told the district judge that for Tihar Jail case, you will have to rely on the existing deficient provisions of law. But in your recommendations for the future, you could specifically recommend that, the provisions of graded punishment, like those in Kautilya, that is lowest of some fine when prison officials denied food, water, or sleep to a prisoner, to the highest of death sentence when a woman prisoner was raped or any prisoner escaped from the jail, and recommend that provisions be made on similar lines.
Sir, isn't Earthsas all about spies, saboteur, espionage, and other murky stuff?
Well, reading Jawaharlal Nehru, one gets that misleading impression. Arthashastra is actually a detailed treatise on governance, including administration of justice, and humanism pervades every part of it. Subjects mentioned by you no doubt form a small part of Arthashastra, since those are also matter of governance.
Sir, what is so special about the ancient Indian legal system contained in that work that we should switch over it?
Well, India's ancient legal system was highly evolved, though my own exposure is only limited to Kautilya's Arthashastra. I haven't read Brihaspati, Katyayan, Manu, Narad, or Yagyavalkya. Our Supreme Court judge, Justice S. Abdul Nazir, has uh, called Brihaspati, Katyan, Manu, Narada, and Yagyavalkya as legal giants in his speech on 27 December 1921. And he has said that they must be compulsorily taught in every Indian law school. To me, what has appealed on the civil side is that Arthashastra has an inbuilt fast track system. For example, it gives time of not more than a week to the defendant to file his written statement. On the criminal side, what has appealed to me is the graded system of punishment for crimes of varying severity. System of prison administration is deeply imbued with humanism, and different types of punishments are prescribed for jail officials for denial of human rights to the prisoners. Rules of evidence for civil and criminal cases are different, just like, let us say, in modern day Britain. We haven't updated our Evidence Act since 1872. Taxation system was also very highly evolved. Needless to add, that system of alternative dispute resolution, that is popularly called ADR, that is consisting of arbitration, conciliation, mediation, etc., is India's greatest gift to world of law.
Sir, with that, I can relate to the last question of the interview. Can books containing slokas be adopted for making laws in a secular polity?
Why not? Assumption that our ancient culture should be a taboo for all public affairs is not correct. Moreover, there is nothing religious in Arthashastra. You see, shlokas are just manner of writing or expression in ancient times. That can't be a valid reason for not owning them or adapting them to our present day needs. To make my point, let me say this more bluntly. Of the millions of books which were burnt and destroyed in 2000 AD, in 1200 AD by Muhammad bin Bakhtiar Khilji at Nalanda University, only a very minuscule part perhaps related to religion. Rest of them all related to architecture, astronomy, chemistry, geography, governance, history, law, mathematics, medical science, metallurgy, planning, subjects that have nothing to do with religion. Is it correct to adopt an illiterate invader's approach in making our choices for serious matters like governance? I don't think so.
So thank you, sir. Thank you for such an enlightening session. With that, we will be ending this session for now.
Thank you very much.